Thank you, Mr. Chairman. I appear here today to attempt to convince you all to put me out of work.
Gladly like to.
Thank you. I'm a trial lawyer, and I provided the members of the committee with my statement previously, which addresses the specific issues that I have seen with Children's Services in litigating civil rights claims on behalf of families against Children's Services agencies and Children's Services staff over the last 30 years. I've encapsulated what I've learned in terms of the dysfunctional aspects of the Department of Child Safety. When I say I want this group to hopefully put me out of work, what I'm saying is I have provided targeted legislative proposals here, which doesn't cost the taxpayers much money and will pay for themselves over time, which I believe will end the need for lawyers like myself to take millions of dollars of taxpayer money on behalf of families. I talked about one case specifically in this statement, the case of Justin, Jackie, and Corin Stein. Corin's name is in the public record because of the civil rights case we won.
Okay.
That's just one example. Now, one thing I would like to address before I close, and that is something that's not in my statement, and that has to do with the Ombuds Office of DCS and whether or not DCS is policing itself properly. It isn't. I have the opportunity to take testimony under oath by representatives of DCS, and in the recent case, I took the testimony of a lady named Sarah Bruce, who happens to be a representative who operates in the Ombudsman's office as an advocate. In her testimony, Sarah Bruce admitted certain things. One is that she doesn't advocate for the parents. She doesn't advocate for the family. Her advocacy essentially is to go, when she hears a complaint and has a complaint assigned, go to the operative field staff, the investigator, the program supervisor, ask them what they did, get the explanation, pass it back to the parents who made the complaint, and that is a satisfactory resolution according to DCS. When the executive director was just here, she had a number of statistics. I would like the committee, if possible, to ask the representative or the executive director to provide this committee with the statistics of how many complaints are lodged and handled by the ombudsman every year, because I have sworn testimony from Ms. Bruce that there are between 10 and 12,000 complaints lodged with the ombudsman every year. And they're all resolved in the same way. I would like the committee to urge the executive director to provide this committee with the statistics which show those complaints which have been resolved to the satisfaction of the complainant, not to the satisfaction of the agency. So, given the short time I have, if anyone has questions, I'm happy to answer those. The statement is quite comprehensive, and I urge you all to read it. Thank you.
Mr. Moore, I've glanced at it, and have you thought about running for office? You said you want to get out of being a lawyer. I just want to give you an outlet for doing what you do so well.
I've been a trial lawyer for 45 years. I'm not going to stop being a trial lawyer.
Okay.
Your Honor, I was about to say.
I was just trying to add a little bit of humor to it. DCS is not the primary focus of this panel. Mm-hmm. What we were trying to do is get an idea of DCS's interaction and how that may affect the family court system. Mm-hmm. Certainly didn't have near enough time to have that conversation, but as you probably heard, I've asked the the Auditor General to add DCS, and it's my understanding that they're already on the list for their decennial audit. So if you don't mind, I would love to have some time after this hearing with you about things that you would recommend be looked at, especially with your intimate knowledge of their operations that came out of testimony. I think that's only natural. If you would make yourself available to my office, I'll make sure that we reach out to you, okay?
I certainly will, Senator Finchim. And one thing I would like to say based on what I've heard today, and that is the issue of these forensic experts talking about the family court. The same thing is true in dependency cases. The experts are on the payroll of DCS. These psychologists that do this are on contract, and they get a substantial portion of their income from doing these. And when they do these evaluations of parents, I've seen so many of them, inevitably there is some finding, no matter what, that there's a concern about the parent's fitness. So I think that's something very important for both the family court and dependency court.
I appreciate that feedback. Thank you. But,
Thank you.
Rest assured, I'll be reaching out to you to have some input into this. I'm always troubled by the throwing around of the term forensically informed.
Like forensic interview.
Yeah.
When the executive director invited you to understand that these investigators are trained in forensic interviews, I've deposed under oath dozens of investigators. None of them have expressed any knowledge of forensic interviewing techniques.
Yeah, so that's what I call croutons on word salad.
There you go.
Okay.
Mr. Chair.
Representative Keshel.
I told you he was awesome.
Yes, you did not disappoint.
So, Mr. Moore, since what you do is lawsuits with this, you defending folks' civil rights.
Yeah.
How, I'm assuming everyone in here understands that the taxpayers are on the hook when there's a lawsuit against DCS.
Yes.
What's the typical cost of that? What are we paying out of our pockets to defend DCS?
I can speak to a number of cases, mine as well. For example, in the case we just tried and won, and the state is going to pay $2.8 million. That is not just for the verdict and the attorney's fees that they have to pay myself and my co-counsel. The state hired outside counsel and paid outside counsel $1.3 million to lose the case. Now, these cases, if you review them, are settled. For example, the Briere case was settled about 5 years ago for $900,000. That was a removal case like all the cases I handle. The children out of the family for a few months, returned to the family, and the state paid $900,000. I settled a case on behalf of my clients Carl and Gretchen Dashke, in which the investigator took the two children for 3 days on a claimed exigency, which the federal district court, Judge Zips, found was unconstitutional, and the state paid $400,000. The problem here, though, is this. The fundamental problem is this here. DCS does not hold those people responsible who are found to have violated constitutional rights. In the two cases that I have where I have achieved victory in the court, not just a settlement, there has been no consequences for the investigator or the supervisor who were responsible for the violation of that family's rights and the horror that they put them through. That's one of the proposals that I have in my statement, a couple of proposals that will end the continuation of these folks who go on to violate others' rights.
Well, coming from a world that has IAD, that would be the Internal Affairs Division of a law enforcement organization, it's never a good day when you get called to that office. And I asked the director if there is an Internal Affairs office. I was rather surprised at the response. No.
Yes.
But we don't want our social workers to feel as though they're law enforcement officers.
Well, in fact, Senator, they are law enforcement officers.
That's
the investigators.
Exactly the point.
Yes, I mean, and I say that in the statement. But the investigators go out to the home of people, and they do everything that they can to diffuse the idea that they're there to determine whether the parents have violated law. They do everything to avoid having to focus that I'm here to see, first, whether the child's in present danger, and second, if the child's in present danger, have you violated law, which takes you either before the dependency court, or I also pass that information on to law enforcement, and you might be indicted.
So you've helped make my point. When you're looking at a happenstance where there is endangerment or neglect, all right, in that moment where you formulate that in your mind as a agent of the state, you have just entered law enforcement land in that instant, because you're going to make a judgment call on what's my next step. So thank you very much for making the point. And
One thing I would like to say, Senator, on
Yes,
that
sir.
briefly. As you well know, a police officer has to go through AZ post training, has to be certified. They receive tremendous education on constitutional rights of the people they encounter. Then when they go to their assignment, for example, the smallest police agency today, because I sue cops too and represent them sometimes, but the smallest police agency today has a policy manual which goes into all of those constitutional rights that they have to use when they encounter citizens. The executive director told you that these core training folks get training from the AG. Well, that might be true, but I have deposed numerous investigators and supervisors who can't remember their training. That's another reason why I propose a certain legislative response.
well, and post requires continuing ed every year. And I've actually met with the director of post and have asked about, what about training on the state constitution? Do we have a reminder about certain things within it? Do we have a reminder? And quite frankly, they don't. So that's another thing that we'll be looking at. It's when it comes to continuing education, it's kind of a free-form thing that each department gets to make a decision about. And as you well know, but maybe perhaps the folks in our audience don't, the Constitution does one of two things. It either prohibits police powers or it enables police powers. Nothing more, nothing less. That's what it's about. And by the way, the Constitution is a restraint on the government, not on the people. So, Ms. Keshel.
I have a really quick to the point, and then I want to let Rep. Fink go. So to your point about all of this, you have an agency who on their website, the DCS website, says that they are self-governing. And
That's a newsflash.
the last I checked was we and the governor and others have oversight over them. So you have an agency saying they're self-governing. That's not even true. And that's why we have an auditor coming in to check them out this fall.
Highly recommend it.
Mr. Chair,
Representative Fink.
I'm going to go back to the family court situation here.
Yes.
And I'd like to get your opinion on this, because what I have seen is that judges have basically taken parental rights away from, like, quote, the good parent without any due process. And so how would you hold them accountable for not following the law? Because they have not, I mean, I considered parental rights a Ninth Amendment right. The founders didn't want to include everything, so they put, because they didn't know if they might miss something, so they have the Ninth Amendment. I consider parental rights a Ninth Amendment right, and they have been denied that right through judges without, any documentation, due process, whatever. So just was wondering, what's your suggestions on that?
Thanks, Representative Fink. Of course, I work in the federal system. And in the federal system, a judge is absolutely immune from consequences outside of being reversed on appeal. We know that. Probably, I haven't looked at the state situation, but I expect it's the same in the state. I would look to legislation which specifically removes judicial immunity under certain circumstances. I haven't thought about that in great detail since this is the first time I've been considering it, but I believe there would be a constitutional way to do that, because obviously judicial immunity is a judge-created doctrine. It's not found in the Constitution. So it can be reversed.
Okay, thank you.
Well, and to that point, there is a question now that has arisen since Chevron. It is the legislature that makes law. not the judiciary. And as far as jurisprudence goes, I get that. That I forget the Latin term for it, but that which has already been decided, we're not going to destroy
Res
that.
judicata, yeah.
Thank you.
Yeah.
It's been a little while since I was
Yeah,
in
it's-
school. So
Me too.
I guess where I'm going with that is we have certain remedies at the state level for judges that are bad actors. And for those of you who are interested, contact my office. We're not going to waste our time with that because it's a long explanation. But the whole concept of court rules in the state, in the state sphere, rules carry essentially the weight of law. And thank you, Representative Culloden, who has shown a very bright light on rule-making authority in executive branch agencies. We are now questioning rule-making authority, and I know that the judges are watching this, so be forewarned. We are looking at rule-making authority within the court, and if that carries the weight of law, then it is a separation of powers issue that needs to come before the legislature to approve such a rule. To your point, it's judge-made law. So,
Correct.
I appreciate your testimony. Members, do we have any more questions? We'll have your contact information, and I would be delighted if you would join us in the working group that's going to be writing the legislation here at the state level. I understand that you're operating in this federal sphere, but I think that you're well informed in some of the challenges that we're going to be facing. So thank you so much for your time.
Whatever time I have that I have beyond devoting to my clients to get them justice, I'm most willing to work with
Well,
you all. Thank you so much.
Oh, and I would, one more thing, it's been, this is a thought that has kind of percolated up here. The outcome of the professional always seems to be captive to the person that's paying for them. Would you agree to that?
Could you repeat that one more time?
The work product of a professional always seems to be tethered to the individual or where they're getting paid from. So, for example, a psychologist. If he's being paid by one party, it would seem that he'll be tethered to that party's interest.
I think what we have to do, of course, in my area, I'm in litigation, so I'm on the opposite side, and my client hopefully can pay me, probably can't, but my position is to further that client. However, I agree with you. It's not necessarily suspicious that an expert who is called upon by the court or is called upon by the agency to conduct some kind of evaluation isn't necessarily biased. However, you must be extremely careful as to that expert's amount of income they get from that, how many times they are involved, and how often they find, for example, that the parent has a mental illness or an emotional illness, or the child has an emotional illness that requires separation from the parent. Those are data that we don't have.
Okay. Thank you very much, sir. I appreciate your testimony.
Thank you.